So most Americans don't even have a will, and even fewer have a living trust. So I'm estate planning attorney Paul Rabelais, and in this video, I'm going to answer the question, if a living trust helps families avoid probate, the generally long public court and attorney involved process when someone dies with assets in their name, why don't more people have a living trust? So let me give you some of the numbers. I was kind of studying some of the recent polls in this area, and it appears that about 30% of Americans say they have a will or a will-based plan. They created a will to leave their estate to their survivors, about 30%. About 10 to 15% said they used a living trust as the mechanism to be able to leave their estate to their survivors, which leaves around 55 to 60% of Americans that have no plan at all. And if you look at the age group, age 65 and older, around half have a will or trust in place. Makes sense. And if you look at the age group that's under 35, the polls say 1 in 5 have a plan in place, which actually sounds kind of high to me. So based on the numbers, if you've done nothing from an estate planning perspective, you're in the majority, but that may not necessarily be a good thing. So what's the deal about living trusts? So living trusts allow you to transfer your assets directly to your loved ones when you pass away without probate, no court, no delay, little or no expense. Let me give you an example. Let's say John and Jane Doe, they accumulated some assets over their lifetime. Maybe they're 65 years old. They have a home. They may even have some rental property. They may own a business. They may own an interest in an LLC. Probably own some investments, a brokerage account, and vehicles and cash, and IRAs and life insurance. By the way, IRAs and life insurance pass to beneficiaries outside of any kind of probate proceeding. So I'll be focusing on those other, what we call probate assets. But John and Jane have some, and let's say their estate, doesn't really matter what their estate is worth. It could be worth $500,000. It could be worth $5 million. It could be worth $50 million. But the idea here is John and Jane, they have assets in their name. And let's say John and Jane, for whatever reason, they decided to use a will to leave their estate to their surviving spouse and then ultimately to their children. So they leave their assets in their name, and let's say John dies first. Well, when John dies, all those assets in John's name are frozen, his investment account. Jane can't ever sell the house, at least not until she goes through this probate process that I'm about to explain. Jane can't sell the business or transact any LLC business because this LLC, John had an ownership or membership interest in it. So when John dies, Jane's kind of stuck. And so what she does is she hires lawyers, goes through the court process, presents John's will to the court. A judge has to rule whether John's will is valid. And then inventories of assets are prepared, filed at the courthouse. Ultimately, a judge signs court orders ordering that the investment company, transfer investment accounts that are in John's name to the surviving heirs, whether that's Jane or other people. And all of the heirs are involved in this court proceeding. Judge signs court orders ordering that real estate be transferred out of John's name to the appropriate heirs. So there's obviously a time and expense factor to that whole process, which let's say that takes a year. And then Jane lives for several more years and then she dies. Now the kids are back to us lawyers going through a court process. Attorneys involved, courts involved, judges involved, lawyers for financial institutions are involved, reviewing the court orders. So then there's another expense, another delay, another set of hassles because John and Jane used their wills to leave their estate to each other and then to their children or whoever they wanted their heirs to be. So that's how it goes with a will plan. The alternative is John and Jane could have set up what's called a living trust or a living trust plan where they created their John and Jane Doe living trust. In addition to creating their trust, they transferred their assets to their trust, transferred their home, transferred their brokerage account, transferred their LLC from John and Jane to John and Jane as trustees of the John and Jane Doe Trust. Trust says they can do whatever they want to with their trust assets while they're alive. Trust says when one of them dies, the surviving spouse stays in control of everything, and the surviving spouse can do whatever they want with the assets, is the way they set it up. And then the trust says that when the surviving spouse passes away, they had named one of the children in the trust instrument to be what's called the successor trustee, and they named all of their children as equal beneficiaries to inherit all of the trust assets after John and Jane passed away. So had they set up their living trust and what's commonly referred to as funded their living trust or transferred assets to their trust, because those assets have to be, as long as those assets are titled in the name of the trust when John and Jane die, they don't have to go through the probate. Probate's for assets that are titled in your name when you die. So again, when John died, Jane didn't have to do anything. And then when Jane died, if the child who was the successor trustee, that child could sell the house immediately the day after John and Jane die, sell the business, transact business issues, distribute the investment account assets to the appropriate beneficiaries, all outside of that court and attorney involvement, saving the whatever the expense was, court and attorney expense, and saving the delay, saving the hassle. So now that's kind of the will plan versus trust plan analysis. So now let's look at kind of why people don't have a living trust, because I've helped a lot of people create a living trust, help a lot of surviving family members when their parents perhaps died with a living trust, helped lots of children when their parents died without a trust and with wills. And so sometimes when people, they go through this process, they ask me, well, Paul, why doesn't everybody have a living trust? And clearly not everyone does, because the polls and the statistics show that maybe 10 to 15% of Americans have a living trust. So let's go through, maybe 5 reasons why people don't have a living trust. Number 1, I'd say it's maybe a lack of awareness and education. You don't learn about estate planning in school. You may not know anything about probate until maybe you have to go through it when a loved one or a parent dies. So I think one reason people don't have a living trust is because people don't know what they don't know. The second reason is I think there's some people who are somewhat educated and somewhat aware, but they have a misunderstanding of maybe the difference between what a will does versus what a trust does. Some people think they're covered with a will. They think, creating a will avoids probate, when in reality, if you create a will and you leave those assets in your name, then that's, a one-way really ticket to probate. But some people think creating a will just eliminates the probate. Some people think that creating a will and leaving assets to a trust, often referred to as a testamentary trust. Sometimes people write wills, they say, in those wills, they say, when I die, I leave these assets in a trust for my spouse and then ultimately for my children. They think that avoids probate, but again, in reality, it doesn't avoid probate, because you need to go through the probate process and get the judges and the lawyers and the courts involved in order to get what you need to transfer the assets from the estate of the person that died to that testamentary trust that was written inside of their will. And then some people, I think there's just a misunderstanding that they think trusts are for the wealthy, but that's just not true anymore. Given the complexity and the length and the hassle factor and the expense of probate, really even people with smaller estates, they can make things easier and less overall expense for their survivors by putting that living trust in place and making sure it's funded correctly. All right, a third reason I think people don't create living trusts is because there is an upfront cost and a perceived complexity. So yes, you don't have to work with a lawyer, but most people do. There's some online and kind of DIY options that are available, but I know most people, when they create their living trust, most people opt to work with their lawyer, so there's an upfront cost. And then there's a cost that would be a cost that you don't have when you create a will. There's that cost of transferring your home and your real estate and other assets to your trust. So there's that upfront cost and kind of perceived complexity of creating a trust. But when you look at the cost of a probate, or really in most cases, when you look at the cost of 2 probates, one for a married couple, one when the first spouse dies and one when the second spouse dies, versus the added cost of creating and funding a trust. Well, creating that trust saves families in the long run when you look at the overall costs involved, not to mention that delay factor and hassle factor that is involved when you have to go through 1 or 2 probates when your parents pass away. All right, number 4 is, I think, fourth reason people don't have a living trust is just that psychological barrier to estate planning in general. It's that human side. It's that fact that planning for death oftentimes isn't fun, or there's that psychological barrier where people procrastinate to putting their estate legal affairs in order. Many people just say, I'll do it later, and later never comes. So even financially, people, I've worked with people of, all kinds of, wealth from kind of scraping to get by, all the way to the, $1 billion plus. And even financially comfortable people put it off because it can feel overwhelming and uncomfortable. So that's a fourth reason, those psychological barriers, why people don't create an estate plan or put a living trust in place. I think a fifth reason why people don't put a living trust in place is because some probate attorneys don't offer it. They are will and probate lawyers. That's how they make their living. They create wills for people, and then they kind of hang around until those people die, and then they kind of cash in on the probate, which is really where the big money is. And again, I'm knocking lawyers a little bit. I'm a lawyer. But I also find that some probate attorneys don't offer this living trust plan or program because I think I'm using a word lazy here, and I don't know if that's the right word, but I think some attorneys are too lazy to learn the whole trust code and everything that's involved in offering this revocable living trust plan service to their clients. And so again, they get comfortable telling their clients to create a will, and that requires the probate on the back end, and lawyers get comfortable with that. So sorry if I'm knocking some lawyers. Not every lawyer is like that, but a lot of people have come to me after going to other lawyers, and I saw that's what they went through. So what I want you to do is in the comments, if you don't have a living trust, or if you've done no planning, you don't have to feel bad about it. Just kind of put the reason why in the comments. You may be helping other people. Maybe it was a psychological barrier. Maybe it's on your list to get done next year. Whatever that reason is why you don't have the planning or that you don't have the living trust in place, know that you're in the majority, but I'd love to hear in the comments what some of those reasons are. Maybe you made a conscious decision, you educated yourself, and you made that conscious decision not to have a living trust. And if so, that's the case. You made an informed decision. So just put it in the comments, and we'll keep educating. We'll see you next time.